to the arbitration itself rather than to the dispute.
Right.
But you'll need to take Russian legal advice on the application of the clause under Russian law. That could be complex, not least because the Russian system does not recognize mediation in the way that English law does. So when I say I would suggest that you have an escalating dispute resolution clause requiring the parties to mediate first before they go to arbitration, I'm looking at through my telescope, my English legal background, where the English courts would require the parties to honour that agreement first. I don't think the Russians...
As a condition precedent to going to arbitration.
Yeah.
Well, and I guess the light in which we're casting this, or the way that we're looking at this now, is that by having an arbitration as opposed to being in the courts, we've avoided, as you said, one type of risk, which is the substantive determination of the courts. It's now going to be substantively determined by arbitration, assuming we can also get a reputable institution, let's say ICC, for example.
Yes.
We have the ICC court in the first instance that would resolve, hopefully, disputes about the conduct, the arbitrator's appointment or their conduct. And so there's even less, I guess, that potentially could filter, you would hope, to the courts.
Yes, I mean, you do need to check out as much a matter of Russian law as to the extent to which the Russian civil courts can intervene in the arbitrator's decision. So, for example, if the arbitrators make a decision which you might consider to be manifestly wrong and incapable of being properly found on the facts and the law, the Russian courts might have a right to intervene. I don't know.
Right. So no appeals in arbitration. Only challenges. Is the seat of the arbitration.
Well, you need to check that out. That's a big risk there.
Great point. And that leads us back over to the question of, is mediation now? Now, given these risks that we're looking at, business really wants to do the deal. They always do. I mean, they always want to do the deal.
Yes.
And we've come to now, we're the lawyers, you and I, or I can be the business person. You're the lawyer. And you're telling them they can't do this deal. Now, can we propose maybe something else that might make this a little bit more acceptable? Mediation. You think that might get accepted by the Russian company? And if we thought that was a risk mitigator, how would we propose it to the Russian company?
I think that before proposing it to the Russian company, you need to educate the Russian company what it is. Because mediation is not very well known in Russia.
So we shouldn't assume they've ever heard of this concept.
You should not assume anything generally. I mean, assumption is, as I said, the greatest mistake you can ever make. And so people don't, as I said, they say, is it yoga or is it, so they don't know what it is. They really don't know what it is. And
so how do you explain that to a Russian company? So mediation, wrong word, they don't understand, it's going to get confused with meditation.
Yes.
How do you go about pitching this or persuading a Russian company that this is an idea to include?
What happened usually when the companies ask me to come and talk about what mediation is, I tell them what mediation is, that it is a process when they make a decision, not someone else. And mediator is helping them to make this decision and to find out their interests, because they're so blind with their positions that they can't see even their interest. It's a very interesting exercise with companies when they start to really investigate what are their real interests. And when I talk with them, usually it results in one of the parties asking me to mediate. And because it's like an eye-opener exercise for them, because they said, we didn't know that exists. And they're very skeptical about that. I just had the first and the only, in my experience, mediation between Russian companies. Because usually it's between a foreign company and a Russian company. And so Russian company said if a foreign company uses that may be something which is used worldwide and we just don't know. But the Russian companies, they don't know about that. And at the end of the mediation, they said, it works.
Wonderful.
Yeah.
Wonderful.
So that was just the and the companies.
Isn't that wonderful to see? Isn't it wonderful? Somebody who's never been through this before. Because I'll share it some other time. A couple of experiences where business managers go through this, and they come back to you, and it's not they say I want to do that again, because rather than being tortured by lawyers in dispute resolution, they said we got what we something we could live with. It was short, it didn't cost a lot, and it was fun.
Yes, and they called me from time to time and said, we're signing a new agreement with them.
Yeah.
Yes. It's a very, but people are not aware of that.
Yeah.
And it's a long way to go.
So you got to educate, you got to bring them around. But you think when you educate the Russian companies, it sounds like there's a reasonable degree of sophistication. It's reasonable, they would probably accept it.
It is reasonable because it's in the culture.
Right.
It's in the Russian culture when you try to solve the dispute, because there's no trust in courts actually, and I don't know how widely it's going to be broadcasted, but it's knowledge that some of the courts are corrupt.
Yes, well, it's not. Russia's not the only country to have that problem,
and that's also the reason. When Russian companies, they have the same problems actually. When one company is in Moscow, for example, and another company is in a small city somewhere, and the company in the small city insists that the litigation is under that regional.
Sure.
So, and for example, this company is the only big company there. You can imagine why they insist on that.
Right.
Mm-hmm.
Because it's...
Well, one of the things when I talk to people, our commercial managers who are negotiating these clauses, is that there are so many options available in dispute resolution.
Yes.
Leaving aside the hypothetical that we're dealing with today, for anyone to ever insist and say, I want this and only this, is just to me a red flag.
Yes.
It's not just the case with Russian companies. I think it is the case of any company. For an important contract. It's one thing if they say, because it's not a big contract for us, we do lots of these. This is our standard, and we can't. We don't have the resources to negotiate, so it's take it or leave it. That's one thing. But where it's a negotiated agreement, both sides are being adequately represented, whether by lawyers or just commercial managers, and these clauses are the subject of negotiation. And you can propose, you can just go through the list. Well, you don't like ICC, what about ICDR? You don't like ICDR? What about UNCENTRAL? What about SIAC in Singapore?
Yeah.
What about regional institution? What about the Milan Chamber? What about the Paris Mediation and Arbitration Institute? I mean, if you want institutional, I could probably give you 50 institutions that are pretty good and could do this arbitration. You don't like that? Here's ad hoc. Here are the other options. So with all of these options available for someone in a negotiated context to say, I want only this, I always tell people, you want to be a little bit curious, as you said earlier.
Yes.
Why are they insisting?
Why they insist on that? There should be something behind
Well,
that.
here we've gotten beyond it. Let's go back to this one, Tim. And I think that we're going to have ultimately a little bit of tension between you and the business here, because we still have risk, right? That we've not...
Can we talk about risk? Because I just wondered what the financing arrangements were here, whether you've got guarantees, performance guarantees, letters of credit. What's the structure
what's
here?
What's the type of dispute that the parties might face? Well, let's say in this one, for example, if we can come to terms here, we'll get paid. It's going to be, let's say, an equipment contract where we will ship the equipment under a letter of credit, and we will be paid as we ship. So, no financial exposure once the equipment's in the country.
Well, you may get claims coming back against you for...
But we might get, the equipment might have problems. There might be a performance bond or a warranty bond under, a bank guarantee or letter of credit that remains open to satisfy our warranty obligations, let's say, under this contract. Or they might not.